Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers mistake of law, disorderly conduct, and deadly weapons, and is brought to us by Code Blue Cam's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, Surfshark. Surfshark is a premier VPN service that offers unparalleled digital security for a fraction of the price of other competitors. Not only do you get to enjoy the luxury of browsing the internet safely and anonymously, but a Surfshark subscription also allows its users a host of other features at no additional charge. One of the many perks included with a Surfshark subscription is the ability to bypass region restrictions on popular platforms like YouTube and Netflix and view content that's not normally available in your country. Thanks to Surfshark, I can still catch my favorite Spider-Man movies, even though they were removed from the US Netflix catalog. A Surfshark subscription is totally unlimited, which means that you can use it on as many devices as you like, and even on all of them at once. No other VPN service offers that much accessibility. Right now, Surfshark is offering the ATA community an 83% discount with an additional 3 months completely free. With 24-hour customer service and a 30-day money-back guarantee, you have absolutely nothing to lose. So, click the link in the description to claim your exclusive offer now. Thanks again to Surfshark for sponsoring this episode. On September 13, 2021, personal injury and criminal defense lawyer Mark A. Metzger III dressed in a costume of Michael Myers from the 1978 horror movie Halloween, which included a mask, a wig, and a bloody-looking knife. Mr. Metzger walked around the mostly abandoned Galveston Beach in Galveston, Texas, just before Tropical Storm Nicholas made landfall, and shared an image of himself standing in costume under the beach's historic pleasure pier on social media. While Mr. Metzger later explained that his goal was to bring, quote, positive vibes to the gloom and doom out there, the Galveston Police Department received several calls about a masked man carrying a bloody knife, and officers from the department responded to investigate.
Walk that way.
The officers approach Mr. Metzger with their guns drawn, handcuff and search him, and begin to walk him off the beach. After the officers place Mr. Metzger in the back seat of one of their vehicles, Mr. Metzger informs them that he had cleared his plan earlier that day with Lieutenant Sims, potentially referring to Lieutenant Destin Sims of the Destin Police Department. Mr. Metzger claimed that he asked Lieutenant Sims if it was illegal to walk around the beach in a costume when he ran into him at lunch, and Lieutenant Sims told him that it shouldn't be a problem. Assuming that Mr. Metzger's conduct was illegal, and as we will discuss later in this episode, it almost certainly was not, it is unlikely that his conversation with Lieutenant Sims would provide him with a defense to any charges levied against him. In general, criminal defendants cannot be exonerated due to a so-called mistake of law, where they were mistaken about whether their conduct was illegal, because all citizens are presumed to know and understand the law. However, a rare exception exists when an individual reasonably relies on an official statement of the law, although courts have narrowly construed the types of statements from government officials that give rise to this defense. For instance, in the 2008 case of De Sabato versus U.S., the U.S. District Court in Massachusetts noted that, quote, As a general matter, reliance on erroneous advice from a government official does not stop the government from enforcing the law, even if contrary to the advice given. This principle applies with particular force when government advice is oral, as oral comments do not permit the government to ensure that governmental agents stay within the lawful scope of their authority. In Texas, the state legislature has explicitly codified the types of government statements that citizens can use to make a reasonable reliance defense. Section 8.03 of the Texas Penal Code states that, quote, "It is an affirmative defense to prosecution that the actor reasonably believed the conduct charged did not constitute a crime and that he acted in reasonable reliance upon an official statement of the law contained in a written order or grant of permission by an administrative agency charged by law with responsibility for interpreting the law in question, or a written interpretation of the law contained in an opinion of a court of record or made by a public official charged by law with responsibility for interpreting the law in question." Because the statute only creates a defense for individuals who rely on certain official written statements, Mr. Metzger would not be able to use his conversation with Lieutenant Sims to defend himself against criminal charges.
Where do you live at?
I didn't do anything wrong, guys. I cleared it with your own people. I was at Mason's for lunch. I asked him if I was doing anything wrong. I could walk down the beach.
Give me a second. Hold on.
The thing about a disorderly conduct is, for some people it might not be alarming, but for others it is. And when people start calling in and they are alarmed, no, I wouldn't say that walking around in a costume necessarily is what's against the law. It's causing the alarm to the general public.
The officer informs Mr. Metzger that he has committed disorderly conduct because he caused panic and alarm to the general public. Under Section 42.01 of the Texas Penal Code, an individual can commit the offense of disorderly conduct in a variety of ways, including intentionally or knowingly displaying a firearm or another deadly weapon in a public place, quote, "in a manner calculated to alarm." Setting aside for a moment the fact that Mr. Metzger's knife was fake, it is important to note that the statute does not require that anyone actually be alarmed for a disorderly conduct conviction to be sustained. Likewise, the fact that an individual's conduct actually caused alarm is insufficient to convict them under this statute. Instead, courts will look to an individual's mental state rather than the consequences of their actions. When analyzing this statute in the 2019 case of State versus Ross, the Court of Criminal Appeals of Texas explained that, quote, "The literal language of the statute does not require the actor to avoid actually alarming another person. Instead, the statute prescribes displaying a firearm in a particular manner, one that is calculated to alarm." The court went on to conclude that, quote, "The phrase 'a manner calculated to alarm' means a manner that is objectively likely to frighten an ordinary, reasonable person. However, because the statute also requires an individual to take such an action intentionally or knowingly, and, now quoting, in an open carry state like Texas, displaying a firearm in a public place is not criminalized because of its very nature, the court reasoned that something beyond the bare act of displaying a deadly weapon in public is required to make a complete criminal offense, and ultimately held that in order to be guilty of disorderly conduct under this section of the statute, a person must intentionally and knowingly display a deadly weapon in a public place, quote, "in a manner that he knows is likely, under an objective standard of reasonableness, to frighten the average ordinary person." In this situation, had Mr. Metzger's knife been real, it is certainly possible that he could have been convicted for disorderly conduct. Charges like this are highly fact-specific, but it's not difficult to imagine a scenario where a court would conclude that Mr. Metzger knew that walking around on a beach holding an apparently bloody knife in a Michael Myers costume would frighten the average ordinary person.
If it's clearly on the beach, 100 yards from anybody, no one's in danger of their life, no one's in fear for their life.
And I mean that
I could almost entertain that argument if it was.
I could understand that
on the sidewalk right here.
And I could understand that part of it as a defense to it, but the here and now.
I'm not trying to plead my case. I'm just, the rest of this is, I'm supposed to be home. I've got court in the morning.
Look, where's your car parked?
In front of Murdoch's.
Okay.
I parked in front of Murdoch's. I walked
So
around.
right now we are just the transporting officer, but I can speak to the other officer. He, at the very least, I could see if he would be willing just to cite you for the disorderly conduct and release you at your vehicle. Okay? Let me go over there and talk to him. All right.
Basically suspicious person, man. Somebody with a knife and a Michael Myers mask walking around.
People with no
Well, let me ask this. You understand why me and the other officer drew our guns on you, right?
Oh, absolutely.
So,
Absolutely.
even from that far, if we couldn't tell that was a real knife, the people up here can't tell either.
That's why I put it down. All orders, cooperate.
Yeah, and we respect that, but at the same time, the people who are just trying to enjoy
I'm not
this...
upset with you guys about it.
The officers argue that Mr. Metzger should have been arrested because the citizens on the beach who were frightened by his costume could not tell that the knife was a fake. However, the disorderly conduct statute requires an individual to display a firearm or another, quote, deadly weapon, and a fake knife is not consistent with the meaning of a deadly weapon under Texas law. Under Section 1.07 of the Texas Penal Code, the term deadly weapon means, quote, a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Applying this definition, the Court of Criminal Appeals of Texas noted in the 1983 case of Blaine v. State that while a knife is not a deadly weapon per se, quote, the state can prove a particular knife to be a deadly weapon by showing its size, shape, and sharpness, the manner of its use or intended use, and its capacity to produce death or serious bodily injury. Clearly, a toy knife would not be considered a deadly weapon that was designed, made, or adapted for the purpose of inflicting death or serious bodily injury. However, as the 6th District Court of Appeals of Texas explained in the 2010 case of Hernandez v. State, quote, objects that are not usually considered dangerous weapons may become so, depending on the manner in which they're used during the commission of an offense. There are myriad items not designed as weaponry which, by their use, the courts of this state have deemed to have been employed as deadly weapons. In the Hernandez case, the court considered whether a hard plastic toy gun with sharp edges could be a deadly weapon, and although the decision acknowledged that the toy gun could potentially cause serious bodily injury as a bludgeon, the court ultimately concluded that because in the case at hand the defendant pointed the toy gun and pretended to shoot, the toy gun was not capable of causing serious bodily injury or death in the way it was used. Applying this precedent, a court would likely conclude that the knife was not a deadly weapon in this situation based on the way that Mr. Metzger used it. Even if the fake knife could potentially cause serious injury as a bludgeon or through another method of use, which is undoubtedly a questionable proposition, there is nothing that indicates Mr. Metzger raised the fake knife as if he would strike anyone or otherwise threaten to hit anyone with the fake knife. For this reason, it is highly improbable that Mr. Metzger could be convicted of disorderly conduct for his actions.
So this guy's a pretty well-known defense attorney. I think he's trying to around. He talked to Sims today, and he's like, hey, can I walk on the beach in a costume? And Sims told him, I don't see an issue with it. I was like, the issue is not you walking in a costume. It's when people start calling in and you're causing panic and alarm, that's disorderly conduct. You walking in a costume is not an issue. It's people that are alarmed by you walking in a costume. I think we are going to cite him just for the DC and release him in his vehicle. And he said, I was like, look, you can either go to jail for it or we can cite you. And he's like, I'd rather take a citation.
The officers cited Mr. Metzger for disorderly conduct and released him without taking him to jail. On December 3rd, 2021, Mr. Metzger shared on social media that the charge against him was dismissed. However, Mr. Metzger later remarked in an interview with Houston Chronicle that he believes the officers made the right decision in arresting him and that, quote, the officers who cited him were fair in how they approached a potentially deranged-looking masked man holding a large knife that was dripping fake blood. However, when discussing the charge, Mr. Metzger also stated that, quote, I knew it was going to be dismissed all along because at the end of the day, there was no crime committed. Overall, the Galveston officers get a C- because although it is perfectly understandable that they initially approached Mr. Metzger and investigated him, once they discovered that the knife was fake, there was no justification for keeping him in handcuffs, placing him in the backseat of the cruiser, or charging him with disorderly conduct. As they attempted to justify their actions to Mr. Metzger, the officers demonstrated a total lack of understanding of the requirements of the Texas disorderly conduct statute, and as a result, they effectively arrested Mr. Metzger for displaying a deadly weapon when he was simply carrying a plastic toy knife. While the officers were aware the concept of alarm was involved in disorderly conduct, they seemed to be completely unfamiliar with the fact that not all behavior that causes alarm is illegal, and made no mention of the deadly weapon requirement of the statute. This encounter demonstrates the inadequate training that many police officers receive and the lack of legal knowledge that is unfortunately all too common in police departments across the country. And it is certainly ironic, to say the least, that all citizens are assumed to know and understand the law when so many law enforcement officers do not. Mr. Metzger gets an A for remaining respectful and peaceable throughout the encounter, complying with the officer's commands instead of escalating the situation, and fighting the charge against him in court instead of trying to argue with the officers at the scene or resist arrest. While I question the soundness of Mr. Metzger's decision to wear a Michael Myers costume and carry a faux bloody knife on a public beach, he was well within his rights to do so, and I applaud him for challenging the criminal charge against him instead of simply paying the $250 fine. However, it is important to acknowledge that Mr. Metzger's legal background and connections certainly aided him in this process, and it can be much more challenging for non-attorney citizens to successfully oppose criminal charges. That being said, this case does illustrate that criminal defendants can win cases when they are unlawfully charged, and I hope it encourages more citizens to fight the wrongful criminal charges they face. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.